I can't do my video because you have stopped it, it says. Good morning, everybody, and thank you for joining us this morning. My name is Michael McEvoy, and I'm the Registrar for the BC Office of the Registrar of Lobbyists, as well as the Office of the Information and Privacy Commissioner. Before we get too far into this, let's just talk a little bit about the joys of working at home, COVID-19 and all of that. My next door neighbor is building a new house, and for reasons that of course make complete sense, today is the day they're digging up the driveway right next to us to put in their sewer line. So if you hear some annoying drilling in the background, I very much apologize for that, but as I say, these are part of the vagaries of working at home these days. So welcome to you all, and it's a pleasure to have this opportunity to speak with you about the upcoming changes to lobbying legislation in BC. You will know that we had planned to hold several of these education sessions in person, but with the COVID-19 epidemic, we are all currently challenged with a Zoom webinar. All the rage these days, it seems, offers us a safer, socially distanced way of communicating. With me today are Oline Twists, our Deputy Registrar of Lobbyists, and Morag Ross, our Registry and Compliance Manager. This is the second webcast we have hosted this month. You may have joined us for the one on April 3rd. If you did, so there are no surprises, this will cover basically the same content as the last one. As with the last session, my team and I will discuss and address questions you have had about the upcoming legislation. Many of you will be wondering, with the challenge of the virus that it is presented for some organizations, whether we are going to be proceeding with the May coming into force date. The answer is yes. The new registry will be online May 4th as planned. Now, I expect that for most of you, that setting up your registration can be accomplished by June the 15th. The same would apply to any filing you may have to do for actual lobbying between May 4th and May 31st. I do recognize, however, that these are extraordinary times, and some of you may find yourself being in the situation of responding to the pandemic and may be unable to transition over to the new registry by June the 15th. It's for that reason I'm extending the transition period for lobbyists who, due to matters related to COVID, require more time to file by June 15th. For those of you in this situation, you now have until September 15 to register in the new lobbyist registry. This extended transition period is intended for those who need it. If this situation doesn't apply to you, you will have to track your lobbying, if this situation does apply to you, you're going to be filing a little bit later than the 15th of June, you are still responsible for recording and all of your transactions from May 4th onwards until the time that you actually register to ensure that it's accurate. I'm going to start off today by sharing with you the role of my office, and then I'm going to provide some background on why we have rules for lobbying BC and talk about the recent amendments government has made to those rules. I will also take a moment to look at how you determine if you are lobbying and whether you'll be required to register in the new lobbyist registry system. Following my presentation, Oline will discuss what the new legislation requires lobbyists to declare in the registry by way of registration returns and monthly returns. And Morag will introduce you to the new registry and the work we are doing to make it easy for you to use. A quick note about questions. For those of you familiar with Zoom and the raise the hand function, that raise the hand function is disabled for the purposes of this meeting and won't be available for that type of questions. But there is, as you can see, an opportunity to actually write out your questions, and so that will happen at the end of the meeting. Now, I guess what I would ask is that before you start your questions, probably wait till the end. We've heard quite a number, certainly in the last session, and since then, offline, lots of questions, and we're going to try to anticipate those questions in the presentation we make this morning. And so if you can hang on till near the end before you start putting in your questions. The other thing I would ask about questions, and we did find this a little bit the last time, There were some questions that turned out to be very specific sometimes to people's business and probably revealing too much, as it were, about those operations. We're happy to take those offline, and all of those will be answered. So if you can keep your questions to of a more general nature, likely everybody would be interested in hearing about, please do that. So to start, I think it would be useful to give you some background on the work of the office and my role as registrar. The Office of the Registrar of Lobbyists is an independent regulatory office of the legislature. As a regulatory office, we manage the registrations in the registry. We ensure that the public is aware of it. We promote the lobbying registration requirements, and we monitor and support compliance with the Lobbyist Registration Act and what it will become shortly, the Lobbyist Transparency Act. In short, my role as registrar is to oversee, monitor, and enforce the Act. It's important to acknowledge, I think, the role that lobbying plays in our democracy. It is by some considered a pejorative term, but as a society, we want government to have access to solid, timely information to assist with informed decision-making. You play an absolutely vital role in that process. There could be no better example of this, I think, than the current COVID-19 crisis. It illustrates just how important it is for government to have up-to-date information from all sectors across BC. Many organizations are attempting to convey to government how the virus has affected them and how government should distribute its resources during this time of crisis. This exchange of information is critical, but equally important to the integrity of our democratic process is that there be a window, a public window on this activity. By providing ready access to lobbying activity by way of our online searchable registry, my office supports the need for transparency, which in turn builds trust in our system of government. So let's talk a little bit about the Act. The Act, as now in place, was passed in August of 2001. And when it was first introduced in the legislature, the Attorney General of the day stated this: "The lobbying is a fact of political life, and lobbyists can have considerable effect on government policy. This bill will create a new act and a new process that will require lobbyists who are paid to lobby government to register and to have their actions and intentions open for public scrutiny." So since that time, recommendations have been made and amendments passed to both strengthen and broaden the reach of the Act. So changes to the Act since that time. The first round of those changes came into effect on May the 1st, 2018, and included a cooling off period for former public office holders from lobbying government for 2 years after leaving their government positions. So who did that affect? Former public office holders. Those folks include cabinet ministers, their staff, including chiefs of staff, ministerial assistants, executive assistants, and administrative coordinators, parliamentary secretaries, deputy ministers, associate and assistant deputy ministers, chief executive officers, or the next most senior ranking executive positions in a Crown Corp or an agency or an association, and then the chair or vice chair of the governing bodies of a Crown corporation, agency, or association. With respect to the former public office positions, I'd like to point out that it is incumbent on lobbyists to declare all of their former public office positions, even those beyond the 2-year cooling off period. So that was the first wave of changes. The remaining amendments to the Act come into force on May the 4th, 2020. I have to confess, woefully unaware of the significance of this date until the Star Wars enthusiasts in my office brought Yoda and gang to my attention. I say now that I'm up to warp speed, let me be the first to say, on May 4th, may the force be with you all as we transition over to the new legislation when the Lobbyist Registration Act changes title to the Lobbyist Transparency Act, or LTA for short. And of course, that's why we're here today. The amendments coming into force this spring will affect all lobbyists, which begs a question. Before I go too much further, I think it would be useful just to look and see how lobbying is defined under the legislation. So the Act defines lobbying as any activity with a public office holder that attempts to influence decisions being made. This includes decisions in legislation, regulation, programs, policies, contracts, grants, funding, or financial benefits. Who is considered to be the public office holder you would be trying to influence? That's a pretty broad term. It's certainly much broader than the term former public office holder, which I just talked about. Public office holders basically pretty much include anybody associated with government. So that begins with MLAs at a government level, Crown Corp, and government folks. So the full list would include, as I said, MLAs, political staff of an MLA or member of cabinet, officers or employees of the government of British Columbia, people appointed to any office or body by or with the approval of Lieutenant Governor and Council, i.e. cabinet, other than people appointed on the recommendation of the Legislative Assembly. People who are appointed to any office or body by or with the approval of a minister of the government of British Columbia. And finally, officers, directors, or employees of any government corporation as defined under the Financial Administration Act. Under the LTA, you are lobbying if you're attempting to influence government. You're communicating with a public office holder by way of phone calls, emails, text messages, letters, in-person meetings, and possibly, depending on the circumstance, even tweets. You are setting up a meeting, and attached to all of these things is that you're paid for your work. So if you do all of these 4 things, you're required to register. There is, however, one very limited exception to having to register. And this exception is, it's I guess, a variation of an exception that existed, but it's a significant change. So it's important to talk about because it really does broaden the parameters of the legislation. So currently, under the existing act, organizations with in-house lobbyists that are lobbying less than 100 hours in the previous 12 months are not required to register in the Lobbyist Registry. That's the situation now. On May 4th, that will change. The 100-hour threshold has been eliminated, and as a result, some organizations that haven't had to register in the past may now be required to do so. We anticipate many non-governmental organizations, societies, unions, not-for-profit organizations will be affected by this change. As I mentioned, there is one exception. Under the Act, an individual is not a lobbyist and doesn't need to register if they meet 3 requirements. They have to meet all 3. Well, first, you're an employee, director, or an officer of an organization that has fewer than 6 employees, 5 or less employees. Second, the lobbying by the individual on behalf of the organization or an affiliate of the organization is done either alone or when it's done either alone or together with other individuals in the organization totals fewer than 50 hours in the preceding 12-month period. Finally, the primary purpose of the organization is not to represent the interests of its members or promote or oppose issues. So the reality is, even small community service organizations with less than 5 employees and less than 50 hours of lobbying will be required to register if their primary purpose is to represent the interests of their members or to promote or oppose issues. This means in almost all cases, associations, organizations, and unions who represent the interests of their members will need to register. If you want to look into this exception a little further, we've set it out in some detail, had a detailed discussion about this in our guidance document you'll see on our website dealing with this very issue. Other changes for lobbyists that I would just point you to in a very sort of higher level here is that, and I would note that Oline and Morag will get into some of the more details about this, but I want to just take a moment to speak about the registrar's enforcement powers. As the registrar, my office has the legal authority to investigate individuals and organizations to ensure that they properly register their lobbying activities in the public registry. Cases of possible non-compliance with the Act come to my office in various ways. For example, newspaper accounts or word of mouth. When we become aware of possible non-compliance, we review all available and relevant information, investigate to see if there's any merit to them, and determine if the lobbyist is compliant with the Act or not. Under the Act, my office can issue administrative penalties up to $25,000 if after an investigation an individual is found non-compliant. The highest fine to date that has been levied, that I've levied, is $5,000. The fines are, I would say, measured, and clearly when you get to larger numbers, it's a case of a lobbyist being guilty of multiple infractions before you get, as I say, to these higher numbers. You can find the guidelines about how we determine the amount of a fine, again, in the Guide to Investigation posted on our website. I should also note as well, and this is new, that it's within my power to prohibit a non-compliant individual or organization from lobbying for up to 2 years. So I need to say I'm also required by statute to publicly report when I find a lobbyist is offside the law. In each case, of course, it's based on the facts of the case, and one of the mitigating factors in any of these cases is the lobbyist efforts to report or correct a contravention. That said, the emphasis of my office has always been on education, because I actually believe virtually everybody wants to do the right thing. That's why we have staff here to help you if you've got questions and can assist you and take you through the process. Yeah, so we are here to help and help you to understand your obligations under the Act. Again, please review our guidance and contact our staff as soon as you have any questions. I'm sure for those of you who have done that, you found our team is incredibly helpful. So one of the things I did want to do before passing it over to O-Line is to thank all of you who have provided really invaluable assistance in reviewing our new LTA guidance documents. As we've developed them, we want to make sure they're as user-friendly as possible. Thank you all as well to those of you who have helped test drive the new registry. The system is designed to be much easier to use than the old system, that is very user-friendly. And that, of course, sometimes things get lost in the translation between the technical work we do and how we know what the end product is. So, so that has been, your input has been very, very helpful, and particularly members of the BC Public Affairs Association who have been instrumental in that. So thank you again. And with that, I'm going to pass it over to my colleague, the Deputy Registrar, O-Line Twist, to take you into more of the details of the registration returns and the monthly returns. O-Line.
Okay. Thank you, Commissioner McEvoy. And thanks to all of you for your patience as we have switched over to this webcast format. I know I myself am enjoying delivering a webcast for the second time in slippers, and I hope that you all are finding little ways to find comforts in these unusual times that we are living through. And including, and in the words of our public health officer, finding ways to be kind, be calm, and of course, to stay safe. I'd also like to echo the Commissioner's assurance that we are here to support you as we transition to the new Lobbyist Registry with the coming into force of the Lobbyist Transparency Act. And I think I'll just say here, it will be a little bit like riding a bike. Everyone is going to have to turn their minds on how to do each of the component pieces your first 3 times walking through the registry. But once you do that, you'll find it's a little bit smoother. So we are here for you to assist you as you go through that process. So let us help you by keeping you steady through as you transition. I'm going to review the information that lobbyists need to include in the registry starting on May 4th. And I am going to be focusing on 2 types of returns that lobbyists are required by the legislative amendments to complete. The first is the registration return itself and the information required for that. And the second is the monthly returns and the information that's required for those. You may have seen that we posted on our website the unofficial consolidated version of the Lobbyist Transparency Act. The official version will be available as far as we understand on May 4th, if not very shortly after. It looks like this. I'll hold it up for you to take a look. and you can find it there. And in my delivery to you today, I'm going to be talking about information that is required in sections 3, 4, 4.1, and 4.2 of that Act. So starting with the registration return. If you have determined that you are lobbying and you are required to file a return, then as of May 4th of this year, you can register as a lobbyist by filing a registration return in the Lobbyist Registry. That registration return is your initial entry or your registration into the Lobbyist Registry. And it includes basic information such as your name, business address, whether you are a consultant lobbyist or an in-house lobbyist. If you're filing for an organization, it's the names of each of the in-house lobbyists that are part of the organization. If you're filing as a consultant lobbyist, it will be the name and address of your client organization. You need to identify which public office holders you expect to be lobbying and whether you are yourself a former public office holder. And you also need to identify the subject matter of your lobbying activities. Note that all of this basic information is already required under the current legislation, and it will continue to be required after May 4th. We've been asked if the client information for consultant lobbyists will be auto-populated in the new registry. And the answer to that question is yes. It is one of the many features that we have built into the new registry just to make this transition a smooth one for us all. So I'd like to highlight as well that when it comes to entering the subject matter of your lobbying activities in your registration return, that vague information will not be accepted. Registrations will be rejected if they provide minimal or non-specific information about lobbying activities. So for example, if you write that your subject matter information is, quote, matters pertaining to energy policy, end quote, then we may ask you to describe those matters more fully. Or if you write, quote, discussions about Bill 123, end quote, we will be in touch and we'll be asking you to specify exactly what it was that you discussed about that bill. So that's the information that is currently required and will continue to be required in the registration return. The legislative changes added new information that filers must include in registration returns. Currently, clients or organizations that are corporations must declare both affiliates or subsidiary relationships. Some of the new requirements that I want to touch on relate to bringing further transparency to entities that can influence the lobbying activities by way of controlling or directing the organization or through funding the lobbying activities. So let me expand on that a bit. One new requirement is to enter the name and business address of any person or organization that, quote, controls or directs, quote, the activities of an organization if that entity also has a direct interest in the outcome of the lobbying activities. So the key language there is controls or directs, or a direct interest in the outcome. This requirement will apply to both corporations and non-corporations. Another new requirement is that the filer has to enter the name and business address of any individual that contributed to the lobbying activity within the preceding 12-month period in the amount of $1,000 or more. And that $1,000 minimum is set out in the regulations. And that is the case if that contributor also has a direct interest in the outcome of the lobbying activity. In each of these cases, the statute requires that lobbyists make reasonable inquiries to determine, in those circumstances, i.e., where there are individuals or entities that control or direct or donate above $1,000 to the lobbying activities. So they must make reasonable inquiries to determine whether those circumstances exist. A recommendation to all lobbyists is that when you make those inquiries, you make them in writing and keep a record of the fact that you've made the inquiry and of the responses that you've received. This is the best way for you to demonstrate to the registrar that you've made those inquiries, should you be asked to do so. We've posted guidance on this area on our website, and really keeping in mind the transparency purpose of the Act, those new requirements for the registration returns are about third-party interests that should be known when the lobbying activity takes place. Another area where an additional requirement exists is in grants. Currently, lobbyists need to declare any grants received from government or provincial entities in the last 12 months. After May 4th, lobbyists will also have to declare any funding from government agencies, or provincial entities received in the last 12-month period, and any funding that was requested in the last 12 months. So the provisions about who is influencing lobbying by way of control, direction, or funding, and the disclosure of funding requests are some of the new requirements that you'll find in the registration returns. A question that we get from new lobbyists is who is responsible for completing the registration return and ensuring that the information in it is accurate? The answer to that question is that the designated filer is responsible. If an individual or organization has hired a consultant lobbyist, then the designated filer is that consultant lobbyist, and they are responsible for filing the registration return. For in-house lobbyists, the designated filer is the most senior paid officer in the organization, such as the president, the CEO, or the executive director. And I want to note here that there is a situation where the most senior in-house lobbyist may be named as the designated filer instead of the CEO, president, or ED. And that can happen when the most senior paid officer does not receive payment for their role. So for example, if you have a CEO that acts as a volunteer or an executive director that is a volunteer in their role, then the next most senior officer that actually gets paid would be the designated filer for your organization. Another question that we've received is, when is a designated filer required to file a registration return under the Lobbyist Transparency Act? It is within 10 days. For a consultant lobbyist, it is within 10 days of beginning to lobby on behalf of a client. And for in-house lobbyists, it must be filed within 10 days of the date the organization first has an in-house lobbyist. We have guidance on our website that talks about 10, 15, and 30-day requirements, and you will find this information there. Turning now to the legislative requirements for lobbyists in relation to monthly returns. The monthly return is a new requirement for all lobbyists. It includes 4 things. First, a lobbying activity report, which reports on the lobbying of senior public office holders for the previous month, whether by phone, email, letters, or meetings, or other communications. Second is contributions, which is a declaration of any sponsorship or recall or political contributions that the lobbyist or their organization has made to an MLA or their political party that they are lobbying. Third is gifts, a declaration on any gifts or other benefits that a lobbyist gave or promised to give to any public office holders. Must be since your last monthly return. And then fourth is ensuring that your registration return is up to date. Before I address each of these 4 items in more detail, I'm going to address the question of when the monthly return is due. Consultant lobbyists and organizations are required to file their monthly return by the 15th of every month, beginning the month after the registration return is first filed. So, for example, if you file your registration return on May 10th, you have until June 15th to file your monthly return for your lobbying activities in the month of May. If you first lobby on May 29th and you file your registration return within 10 days on June 5th, then you would have until July 15th to file your monthly return. So again, you file your monthly return by the 15th of every month, beginning the month after the registration return is first filed. These timelines are also set out in those same guidance documents on the 10, 15, and 30-day requirements. that are available on our website. So let's look more closely at the lobbying activity report. This is where you enter information about your lobbying activities with senior public office holders in the previous month. You must file a lobbying activity report for each lobbying activity that you carry out. For those of you lobbying federal government, monthly lobbying reports are going to sound familiar to you. That's how they are structured at a federal level, and they start here in BC on May 4th. For our purposes, you need to be aware that lobbying activities directed at a senior public office holder must be declared in your lobbying activity report that is submitted as part of your monthly return. Also note that senior public office holders are a subset of public office holders, and they are defined in the LTA to include the Premier and ministers or members of the Executive Council, staff of the Premier or a minister other than administrative support staff, MLAs and the staff of MLAs other than administrative support staff. Parliamentary secretaries are considered senior public office holders, as are deputy ministers, chief executive officers, or positions of comparable rank within a ministry. Associate deputy ministers and assistant deputy ministers or positions of comparable rank within a ministry are also senior public office holders. And last, for provincial entities, which are entities outside of core government, they include entities such as crown corporations, school districts, health authorities, and post-secondary institutions. It includes the senior or next most senior ranking executive position and the chair or vice chair or the equivalent positions. For your reference, these are also, in addition to being in the LTA, we've set out those definitions in our frequently asked questions and in our guidance documents where relevant. So your lobbying activity report must include the following things: the name and position title of the senior public office holder who was the object of the lobbying activity, where they work, so the name of the ministry or the provincial entity of the senior public office holder. Other details that must be included in the lobbying activity report are the date of the lobbying activity and the details to identify the subject matter of the lobbying activity. And like the registration return, the subject matter section requires you to provide a clear and concise description of your lobbying activities. So anyone looking at the registry could easily identify and understand your lobbying goals. Organizations must also include in their monthly report the names of the in-house lobbyists who participated in each lobbying activity reported. And I want to take a moment here to answer a few questions that we have been getting about lobbying activity reports. One is based on the fact that the LTA defines lobbying to include a meeting or arranging a meeting between a public office holder and any other individual for the purpose of attempting to influence any of the items enumerated under the definition of lobbying. The question is this: if I have an email string arranging a meeting with a public office holder, and that string straddles a number of days, then what date do I enter into the registry as the date of the lobbying activity? In this case, the date to enter into the registry is the date of the first communication with the public office holder. This is important because if this is your first lobbying activity as a lobbyist, then that date triggers the requirement to complete your registration return within 10 days. Note that if the email string is in fact an email string of lobbying communications rather than an email string to arrange a meeting to lobby, then the same principle applies. You can list the first day of the email string as the date of the lobbying activity if the subject matter being discussed throughout the string remains the same. Another question that we are getting about lobbying activity reports is, do I have to file a monthly report in a month where I do not do any lobbying for my organization or my client? And the answer is no. Section 4.2 sub 5 of the LTA says a monthly return is not required if no lobbying activity occurred in a month. However, note that you would still be required to update your registration return in a month that you have not lobbied if any of the information in that registration return has changed. Another question we get is, if I send a lobbying communication by email to a minister and I copy the ADM, then do I need to report it as a lobbying communication to both of them, or can I just report it as a communication to the minister? And the answer to that is yes, it is both of them. You need to identify in one lobbying activity report the name of both of the public office holders that were the target of your communications. And as you're likely gathering, the information the statute requires to be submitted in lobbying activity reports are at the heart of the legislative amendments that we are discussing. And they significantly inform the purpose of the Act to bring transparency to lobbying activities in BC. Now let's look at the requirements for declaring contributions as they relate to elections activity. To promote transparency, the legislation requires lobbyists to declare in their monthly returns whether or not they have made any of the following three kinds of contributions: political contributions, as defined in BC's Elections Act, sponsorship contributions, as defined in BC's Elections Act, or recall contributions, defined under BC's Recall and Initiative Act. So starting with political contributions. For the purposes of the LTA, they include contributions made to an MLA that you have lobbied, or to that MLA's political party or constituency association. They are an amount of money or the value of property or services provided, with some exceptions for things such as volunteer services. Sponsorship contributions are when a contribution has been made to a third party sponsor for the purposes of sponsoring election advertising. So these contributions have been made indirectly to an MLA that you have lobbied or to that MLA's political party, because that third party sponsor takes the contribution that you've made and in turn sponsors election advertising that promotes the election of the then candidate that you are now lobbying. Recall contributions are contributions toward a petition to recall an MLA, and lobbyists must declare them in the registry where a recall is in relation to an MLA that they are lobbying. The relevant period to consider in declaring one of these kinds of contributions is the same for all three of them. It is from when the date the writ was issued from the last provincial election, which in our case is April 11th, 2017, to the date of filing the monthly return. We have worked to set up the registry so that if you have, when you first come in and answer this question, you've answered it going back to April 11th, 2017, then in the intervening monthly reports, when you're making this declaration, you're making it between the time that you last made it and the time that you're currently making the declaration. So on or after May 4th, a lobbyist will have to declare any of these three contributions made between April 11th, 2017 and the date that they are filing their first monthly return. This step in completing the monthly return is an easy checkbox. Filers simply indicate yes or no as to whether they have made one of these three reportable contributions in relation to a lobbying activity. The lobbyist legislation does not require any other details about the contribution to be submitted to the registrar. And like other areas I've spoken about, there is guidance on contributions now available on our website. Now let's delve into the third requirement of monthly returns. This is the new legislation pertaining to gifts. The new rules and reporting requirements for gifts are consistent with those that are set out in the Members' Conflict of Interest Act. They mirror the rules for MLAs, though notably, the lobbying gift rules apply to all public office holders, not just MLAs. The rule is, after May 4th, the legislation prohibits a lobbyist from giving or promising to give, directly or indirectly, any gift to any public office holder that the lobbyist is lobbying. And remember that public office holders is the larger group that you are identifying in your registration return. distinct from the senior public office holders that you're identifying in your lobbying activity reports. There is an exception to the gift prohibition. It is that a gift can be given to a public office holder if two requirements are met. The first is that the gift is given or promised under the protocol or social obligations that normally accompany the duties or responsibilities of the office of the public office holder. And second, that the total value of the gifts given or promised is less than $100 in a 12-month period. And that $100 is set out in the regulation. Noting here that if your gift to a public office holder meets those requirements, then it may be given, and the legislation requires that those gifts must be declared in the registry. Gifts given or promised under the protocol or social obligations that normally accompany the duties or responsibilities of the office of the public office holder include things like a token of gratitude when you have a public office holder attend a conference or event as a keynote speaker. For example, giving a mug as a gift of appreciation to a minister or a deputy minister that speaks at a conference your organization has hosted likely meets the exceptions, and the value of that mug would need to be declared. Gifts can also include meals and beverages. We have received oodles of questions in this area, and the answer to those questions is that it often depends. If an MLA that you are lobbying is delivering a lunchtime keynote at your conference, then offering them lunch would likely be permitted as per the exception, and you would still have to declare the value of the lunch in the registry. It's similar for receptions as well, depending on the context. And if the value of refreshments are reasonable, then as a gift, they likely meet the exceptions test. But if you are serving caviar and $500 bottles of wine at your reception, then you are very likely to go over the $100 limit, and you would not meet the requirements for the exception. Or if you invite a minister or a deputy minister that you're lobbying to deliver a keynote talk to your organization's executive in box seats at a professional sporting event, which is a time that I think we all hope to return to soon, but we're likely going to take a closer look at something like that. It would likely not be permitted under the gift rules in the LTA. Our online guidance addresses everything from receptions to luncheons to token gifts to complimentary tickets and various kinds of events. I encourage you to review it, and if you still have questions, then please contact us by email is best right now. Keep in mind, the principle that will guide you through this area is transparency. If you do give a gift, it must be declared in the registry. The fourth requirement to complete your monthly return is very straightforward. It's simply that lobbyists are required to make any relevant updates to their registration return when they file their monthly return. We've designed the registry to prompt you to turn your mind to this question every time you go in to submit your monthly returns. So I'd like to take a minute now just to do a quick recap, because I've covered a lot of the territory under the LTA in terms of the requirements for returns. As Commissioner McEvoy discussed, you first need to identify whether or not you are lobbying. If you are lobbying, your designated filer must file a registration return within 10 days of hiring an in-house lobbyist, or if you're a consultant lobbyist, within 10 days of starting to lobby. You are required to include basic information about your organization's lobbying activities in your registration return, including information about who may control or direct the organization's activities, and any grants received or requested from government agencies, or provincial entities in the previous 12 months. In addition, lobbyists must file monthly returns starting on the 15th of the month following the month your organization's registration return is first filed. Requirements for monthly returns include specific information about lobbying activities in your lobbying activity report for the previous month, information about political recall and sponsorship contributions, information about gifts, and relevant updates to your registration return. Our goal is to make it as easy as possible for everyone to understand and comply with the new legislation. And remember that registering your lobby activities will be a bit like riding a bike. Once you sort a few things out, you're going to be well on your way. We have worked really hard to design the registry to be easy to follow, a step-by-step process for lobbyists to submit their information as required by the legislation. And we have lots of FAQs and guidance documents on our website to assist in the transition. And we will be with you on May 4th when the legislation comes into force. So you know how to reach us if you have any questions. And now I would like to turn it over to my colleague, Morag Ross, who is our Registry and Compliance Manager. She's going to give you a sneak peek at what the new registry looks like.
Hi, Oline, thanks. And thanks to everyone for joining us today. I apologize for my background. I set it up for a meeting with some staff the other day as a joke, and I forgot to take it, and now I'm not quite sure how to do that. So hope you can just think of nicer times when you're listening to me talk over the next 10 minutes or so. And I'll just start by saying that we're working very hard on the new Lobbyist Registry, which will be easier for both lobbyists and the public to use. All registrations from the current Lobbyist Registry will be migrated over to the new registry. And to prepare for the change over to the new Lobbyist Registry, the current registry will be taken offline on Thursday, April 30th at noon. And the new Lobbyist Registry will be available to public and to the lobbyists on May 4th. There will be a transition period. Lobbyists will have from May 4th until June 15th to submit a new registration, to update their current registrations, and to file their first monthly return for any lobbying activities in the month of May. Or if you require more time due to COVID-19, you have until September 15th to update your registration and to file monthly returns for lobbying in May, June, July, and August. If you are currently registered, please log on before April 30th and ensure your existing information in the Lobbyist Registry is completely accurate and up to date. In particular, if you have not already done so, please check your active registrations for the exact legal name of your client organization has been entered and the correct designated filer is entered for your organization. In addition, before April 30th, please complete a search of the Lobbyist Registry and note the exact spelling of the first and last name of the existing account holder, the person named in the most recent registration, and their exact email address. You will need this information to activate your account after May 4th in the new Lobbyist Registry. On May 4th, when you go into the Lobbyist Registry, you will see the sign-in page. First, I want to let everyone know that you will no longer need a BCEID, username and password to log into the new Lobbyist Registry. Everyone will create their own username and password in the registry which you use to log in. You will also create a secret question in case you forget your password, and registry staff will have the ability to reset your password. New users will need to create an account. The Lobbyist Registry user guides will be posted on our website May 1st to walk you through that process. Existing users, lobbyists with a registration in the Lobbyist Registry anytime between 2010 and when the registry is taken offline on April 30th, will first need to activate their existing account before submitting a new registration return or updating a registration return. To activate an existing account, you must provide the existing account holder's first and last name and email address. As I mentioned, the existing account holder is the person named in the most recent registration in the Lobbyist Registry, the consultant lobbyist, or the designated filer for the organization. Once you have entered your name and email address, you'll be sent a link to the email address you entered. You then click on the activation link to activate your account. And you can create a username and password and a secret question, and you'll be linked to your registrations from the old registry. You will be given 1 calendar day to click on the activation link, after which time the activation link will expire. Again, our Lobbyist Registry user guides will have details on how to activate an existing account. If you have an existing account and enter an incorrect name or email, a message will appear directing you to contact our office for assistance. Email is the best way to reach registry staff at this time. And please include a phone number so we can call you if that's easier. Once you have successfully set up your account and logged into the Lobbyist Registry, the dashboard is your one-stop shop. This is where you will update your current registration, start a new registration, or complete a lobbying activity report of your lobbying activities involving senior public office holders. Any messages for you from our office will also be displayed on this screen. And any current registrations that are in active or termination pending status when the registry is taken offline on April 30th will be located here under the Current Activities tab. If you have an active or termination pending registration, you will click on the Update button to update your registration and fill in new information. This button is not on the screen now, but will be there when you log in on or after May 4th. You also go to the Current Activities tab to complete your first monthly return. Where it says Activity Reports on the right side of the screen, you would click Add New. If you do not have an active or termination pending registration on April 30th, you would look under the Previous Activities tab for any inactive previous registrations you had in the previous registry. These are registrations in terminated status in the previous registry, or sorry, in the current registry. And the New Activities tab is where you would go to complete a new registration if you've never been registered before, or if you're a consultant lobbyist who has a new client. Another change is that organizations will no longer need to re-register every 6 months. Organizations will only ever have one registration with different versions of that registration when you update your registration. Even if you've not lobbied for 2 years, you would just reactivate old registration. You would not a new registration. And this is true for consultant lobbyists too. If you had a registration for a client 2 years ago and they ask you to lobby for them again, you would not would reactivate the old registration for this client and update the registration. This image gives you an idea of the first step of completing a new registration. There are 7 steps to complete a new registration. You can fill out the steps going from step 1 to 7, or you can jump around and fill the information, the steps in out of order if you wish. You can also complete some information, save, and come back later to complete the other sections. You do need to certify your registration before it can be submitted. And this is what the lobbying activity report looks like, step 1 of 3. This is where you enter information about the lobbying of senior public office holders you actually did in the previous month. You have until the 15th of the following month to complete your lobbying activity reports for your lobbying activities in the previous month. You can also complete your lobbying activity reports as they happen, or once a day or once a week. You don't have to wait until the 15th of the next month. The 15th of the next month is simply the last day you can complete your lobbying activity reports in order to be compliant with the Act. And you must complete 1 lobbying activity report for each lobbying activity. For example, if you have 1 meeting with 4 senior public office holders, you would complete 1 lobbying activity report and name all 4 senior public office holders. Or if you have 4 meetings with 4 senior public office holders, you would have to complete 4 separate lobbying activity reports. And organizations must also enter all of their in-house lobbyists in attendance at the lobbying activity. We have posted screenshots of what the lobbying activity report pages look like on our website, if you'd like to see what these look like, and you can look under Using the Registry on our website to see these. There are a number of searches you can do of the Lobbyist Registry, and you don't need to be logged in to do these searches. There are a number of, these screenshots show you where the search functions are on the registry. You will have the ability to search any of the fields that are entered. For example, you can search for lobbying activity reports with a particular senior public office holder, or you can search for consultant lobbyists who indicated they gave a political contribution. In addition, the Lobbyist Registry is set up so that the public can run their own statistical reports in areas such as registration returns submitted in the last month or lobbying activity reports submitted in the last reporting period. So this is what the new landing page will look like for the new Lobbyist Registry. And this landing page will show recently posted registration returns and lobbying activity reports, as you can see on the left side of the screen under Just Posted. And you're able to click into any of these directly. So if you saw something of interest to you, you could click right into that lobbying activity report or into that registration return. There will also be statistics posted on this landing page on the numbers of new and updated registration returns and lobbying activity reports in the last 2 months. As we've mentioned, we've developed a number of guidance documents to help you understand various sections of the Lobbyist Transparency Act, as well as FAQs. And there were 2 new guidance documents posted, believe it was yesterday or the day before. So if you haven't already done so, I encourage you to go to our website and take a look at these. So some important days in the next little while. The existing Lobbyist Registry will be going offline at noon on April 30th. And the new registry will be available starting at 8:30 a.m. on May 4th. And that's when, of course, the new legislation comes into force. Lobbyists have until June 15th to submit new registrations, to update their current registrations, and to file their first monthly return for any lobbying activities in the month of May. If, due to COVID-19, you require more time, the transition period is extended to September 15th. The extended transition period is intended only for those who require it. It is really important to note that if you are updating a registration that was active in the previous registry, to backdate the start date of your registration to May 4th, when you update your active registrations, as your updated registrations are a continuation of your registrations from the old registry. Also, if entering lobbying activity reports in September, for example, you must choose the date the lobbying activity occurred and backdate if necessary. There are also automated warning emails from the registry that are sent out when you register late or submit a late lobbying activity report. We will not be turning these off, so if you do backdate a registration or lobbying activity report, you can expect to receive a warning email. Just know that we will not be taking further action in these cases, even though you receive a warning. I would also encourage you to please call or email our office if you have questions. Our contact information is here on the very last slide. And I thank you for joining us today. Now I'll hand things back to Registrar McEvoy.
Thank you very much, Morag. Lovely background, I have to say, and takes us to another place. Many of us may not get another holiday to places like that for a while. So big changes obviously coming, and a lot of work to be done, and certainly our team, Oline and Morag and others have been working behind the scenes to get the new system, which we think will be much easier to use, up and running. So hopefully we'll have covered off a number of your questions, but there are a number more online, and so we will attempt to deal with a good number of them here as we enter the afternoon. So thank you for the questions. Keep them coming. What we're going to try and do is maybe if we can find some themes in there to try and do that and answer them. I'm just out of the pile, I'll just randomly start. If somebody's asking whether all interactions with BC Lottery Corporation, whether employees of the BC Lottery Corporation are public office holders. This is a broader question, even because there are obviously other crown corporations and so forth. The answer is yes. They are public office holders. However, what you have to file in your monthly reports when you do it, if you're lobbying, for example, the BC Lottery Corporation, if you talk to a policy analyst in the BCLC, that's not something you would note on your monthly report. But if you talk to the chair of the board, or you talk to the CEO or their second in command, or the second in command of the board, yes, you would have to register that information in as part of your monthly report. With that, I'm going to just turn it over to my colleagues who are looking at the list of questions as well, and attempt to answer those.
Yeah, and I would just, Michael, add to that, generally for your question, for any entity, BC Lottery Corporation is a provincial entity, so it does need to be recorded as in your lobbying activity report if you're lobbying at the CEO or vice level. But generally for the registration return, where you have to identify public office holders generally, it's any entity that is considered an officer, director, or employee of any government corporation as defined in the Financial Administration Act. And Morag can correct me if I'm wrong, but I believe we've set up a drop-down menu within the Lobbyist Registry, so you'll be able to find those entities when you go in to complete your registration returns and your monthly returns. I got that right? Yeah, Morag?
Yeah.
Okay, great. Another question that I see here, when the commissioner was talking, somebody had asked about where the exception can be found. I believe the question was referring to the exception as to whether or not you are actually lobbying. So if you have a copy of the unofficial consolidated version on our website, you can find that in section 1 of the Act. It's in subsection 4. And it sets out that an individual is not an in-house lobbyist if the individual, as the commissioner set out, is an employee, director, or officer of an organization that has fewer than 6 employees. And it sets out the fewer than 50 hours of lobbying in the preceding 12 months, as well as it can't be an entity that exists to promote the interests of members or to promote or oppose issues. So again, that exception to whether or not an individual is an in-house lobbyist can be found in section 1 of the Act, subsection 4. Just reading a question here. This goes back to the first question that we started with. Must we report all interactions with employees of provincial entities or only senior public office holders? So again, you must report for those provincial entities that fall under the officer, director, or employee of any government corporation as defined in the Financial Administration Act. You need to identify those in your registration return. It's not until you get to your lobbying activity reports on a monthly basis that really you're only thinking about the most senior people in an organization. So you're identifying what's defined in the Act as the senior public office holders in the monthly reports. So I'll turn it over to Morag now, who is going to answer a couple questions as well.
Thanks, Oline. So I have a question here that says, just to monthly returns are only if I'm lobbying senior public office holders, correct? If I just engage with a public office holder, a monthly return isn't necessary, correct? So this is a common question that we've received, so thanks for asking it. That is mostly correct. So if you are lobbying a senior public office holder, let's say an MLA, yes, you need to complete a lobbying activity report for that activity. If, however, you're lobbying, let's say, a policy analyst in a ministry, you're correct in that you don't need to complete a lobbying activity report for that interaction, but you do need to ensure that your registration is up to date. And you need to make sure that the ministry that policy analyst works for is listed as one of the public agencies in your registration return, and that the details and subject matter of that interaction with the policy analyst is also in your registration return. But you do not need to complete that monthly return in terms of a lobbying activity report. So that was one question I was going to answer, and let's see. What was the other one? There's another question just about with a copy of the presentation being able to access again. So yes, we will be, as we did with the earlier webcast on April 3rd, we will be posting this on our website, so you can watch it whenever you like, or you can share it with anyone you like as well. And I think I'll turn it back to Oline, who's going to answer a few more questions now.
I'll jump in, actually.
Okay, that's great.
I see a question, we do get this often as well. It says, if our nonprofit is asked to consult on legislation by a minister, is that considered lobbying? And the short answer is no. And section 2, sub 2, sub C says if any representation made or submission made to a public office holder, as the Act reads, in direct response to a written request from a public office holder for advice or comment on any matter referred to, and you'll see those references, essentially the answer is no. If you are asked for comments directly from a public office holder, that is not considered to be lobbying.
Thanks. I see another question that's somewhat related to that, so I'll go to that one now, which is a question of whether or not educating government, and this is from the context of a nonprofit, though certainly any lobbyist might be in a position of providing some education on service gaps related to a population that they represent. Is that considered lobbying? So we didn't set out very basically what constitutes lobbying at the outset. It is set out in the Act under the definition of lobby in Section 1 of the Act. And it says it's to communicate, there's two parts to it. So the first part is communicating with a public office holder in an attempt to influence any number of a list of things that are enumerated there. So that includes a legislative proposal by government. It includes a bill, whether it's its introduction, amendment, passage, or its defeat. It includes trying to influence any regulation, its development or enactment. It includes trying to influence programs, policies, directives, or guidelines of government or of a provincial entity, whether they're being developed, established, amended, or terminated, and any contract, grant, or financial benefit, and its award, amendment, or termination. And there are a couple of other things listed there as well, which are related to Crown, corps, or provincial entities. And you can see just from the list, it's very, very wide. So if the information, quote unquote, that you are providing is in an aim to influence any of those things, then it would be considered lobbying. And of course, the other area that's considered lobbying is to arrange a meeting between a public office holder and any other individual in attempting to influence any of those matters that are set out in that list. So you want to be careful if you are being, so if a minister is coming to you to solicit information, that's one thing, and we would always recommend that you keep a record of that. Should it come into question, then you can demonstrate to us that that conversation was initiated from the minister. If you are initiating the conversation, if it's simply to inform the minister with some information rather than, for example, to influence any of those things set out in the definition of lobby, then it wouldn't be. But if you are aiming to influence, then it would be lobbying. And another question here is whether there's a penalty for reporting an activity that is not lobbying. And what do you do if you're unsure if something's lobbying? So under the Act, lobbyists are required to put accurate information into the registry. So there can be a penalty if you report information inaccurately. However, if you're not sure about an activity, then please contact our office and we would be happy to discuss the details of that with you and whether or not, in our view, it falls within what's required to be reported. I'm going to bounce over to Morag now.
That sounds great. Okay, so I have another question here about basically the registry, saying, will another staff person in an organization be able to fill out a lobbyist registration or monthly lobbying activity report on behalf of the designated filer, and then be able to share that information with the designated filer so they can review and ultimately submit the information? Another good question, and one we've received a couple times, and the answer is yes. The new registry will have something called a representative account. So, and this is something that the designated filer, whether the designated filer is the most senior paid person in an organization or a consultant lobbyist, they can basically, once someone has created a representative account, they can link that to their own designated filer account, and they can let the representative enter information into the registry, and then the designated filer can sign off and it can certify and submit that to us. So the designated filer is the one who's ultimately responsible, but they can delegate a representative to enter information into the registry.
Question, a really interesting question. We've had it a number of times on Twitter and tweeting, and how might that, in what circumstances might that constitute possible lobbying? I think any pronouncements on Twitter that are to the wider world, those are not likely to be lobbying. But as you know, Twitter provides a function where you can tweet directly at somebody. So you can name, for example, a minister's Twitter account, or you know, a senior CEO of a Crown Corporation's Twitter account. If it's an attempt to influence that person in that way directly with something that you're trying to achieve on behalf of a client, that would, in all likelihood, be lobbying. I think there's similar features perhaps on other social media sites, some maybe that I'm not as familiar with, but I think LinkedIn, I think, also has a thing where if you fill somebody's name in, it basically links to that person's site that they would see it when they open it up. So it's kind of a similar logic would apply to something like that. But general tweets to the world, probably not. But if you're directing them specifically at a minister in an attempt to change their mind on a policy, legal matter, or otherwise, would likely do so. I think it's back over to Oline.
Yeah. So I am looking at a question that's asking about whether or not directors who don't get paid for their activities are considered to be lobbying. And this individual has given the example of someone that also gets paid an honorarium for their director duties. And that's actually a question that we hear quite often. So under the Act, essentially, if you are receiving payment for your activities, then if those activities are under the definition of lobbying, then you would be considered lobbying. And an honorarium would qualify as that. But of course, volunteers who are not getting paid or receiving any payment in any way would not qualify as lobbying.
Okay, I can jump in and answer a question here. Ooh, I just lost the question. Sorry, here we go. For in-house lobbyists, assuming employees greater than 5, what if that is just part of their overall job and not hired specifically to do lobbying? So another good question. And basically, it doesn't matter if you've been hired as a lobbyist or as something else. It just matters if you are getting paid for the performance of your duty. So if you're getting paid and if you are lobbying, then you're an in-house lobbyist just by virtue of meeting that test. So you don't have to have a job title as a lobbyist. It just matters if you're getting paid and if you're communicating with public office holders in an attempt to influence any of the matters under the definition of lobby in the LTA.
Right, and I'm going to flip it back to Oline now as we have another, I think about another 10 minutes or so left for the afternoon. Lots of great questions. And I would remind everybody, by the way, this is not the end of the session. In fact, we continue to answer a multitude of questions every day from people phoning in or sending us emails. So this is part of the continuing process as we work towards bringing into force the new legislation, and we'll continue thereafter as we always have made ourselves available. With that, I'll turn it back to Oline.
Thanks. One of the questions here is asking us to confirm whether the 100-hour threshold spent lobbying and preparing to lobby will be eliminated as of May 4th. And as the Commissioner identified, yes, it will be eliminated as of May 4th. There's a follow-up question here, which is that it's still appearing on our website. So if you go to our website right now, you're going to see a section on the Lobbyist Registration Act, and there will also be a section on the Lobbyist Transparency Act. We have information about both acts up there right now because we wanted to make information about the Lobbyist Transparency Act available to you in advance of the May 4th coming into force date. So just be mindful as you're looking at information on our website, the guidance that you want to be looking at in relation to everything from May 4th forward is the section under the Lobbyist Transparency Act. There's a guidance under there, whereas guidance under the Lobbyist Registration Act is guidance relating to the current legislation. So just be mindful, they're both up there at the same time. And if you're looking for information about the act coming into force on May 4th, you want to be under the Lobbyists Transparency Act section of the website.
It's great, and it's back to the woman who's dipping in the water there. Morag.
Thanks, Michael. So there's another question here just about organizations. Says, do I understand correctly that 6-month renewals will no longer be required? And the short answer is yes, that is correct. So organizations currently under the Lobbyist Registration Act have to re-register every 6 months. Under the Lobbyist Transparency Act, that is no longer. So an organization will only ever have one registration. So you register once, and then you'll just update that registration as time goes on. Even if the designated filer changes, the organization will just have one registration. So it may be a little bit more involved to complete your first registration in terms of there are 7 steps, but once you've completed that, then you don't have to be doing it every 6 months the way you have been in the past. Okay. And I think I'll turn it back to Oline. She's got another question for you.
Yeah. So I have 2 questions here that I'm going to address. The first one relates to the controls or directs provisions that I mentioned. And the question is, do you need to file a person or business that controls or directs the activity of the organization if they are volunteer members of the association? And the answer to that is yes. The legislation does not care about whether or not the person who is controlling it is getting paid for that control. The fact is that what the legislators are looking for is transparency as to third parties that may be influencing the activities of the organization. So it could be by way of a legal mechanism, it could be by some other means, but in any case, you're required to identify those folks in your registration returns. And the second question that I'm looking at here goes back to something that we talked about earlier. And again, I'll point you to the definition of lobby in section 1 of the LTA. The question is, if you're talking to government staff, so not senior staff, so presumably nobody in the definition of a senior public office holder, about the application of existing laws, regulations, and policy, and you're not trying to change those policies, do you have to include that in the registry? And if you look at the language in the definition of lobby, you'll see that it's very, very broad. So you don't actually have to be trying to change, for example, regulation. You could be talking about its development or when it gets enacted. You don't have to be trying to change a legislative proposal. You could be talking about the development of it. Or when it comes to bills, it's introduction or amendment or passage or defeat. So you want to look at what is in that enumerated list under what it means to be lobbying. And that is going to be your guide as to whether or not your communications with a public office holder and what you're trying to influence fall under the definition under the Act. I'll pass it back to Morag.
All right, so we have another question here about the registry asking, does every in-house lobbyist need to submit a monthly return, assuming they undertook an activity, or is it one monthly return for the entire organization identifying each activity? So it's basically, so I guess I'll just back up and say an organization completes one registration return and lists all of their in-house lobbyists in that registration return. And then each month, by the 15th of each month, the designated filer for that organization is the one who's responsible for listing all of the lobbying activities. So they will do one lobbying activity report for each lobbying activity. So for example, if your organization had a meeting with 3 senior public office holders and 2 of your in-house lobbyists were in attendance, you would do one lobbying activity report and name all of the senior public office holders in attendance and name all of your in-house lobbyists in attendance.
Okay. I'm on to the next. So we're not short of questions here, which is great. And I'll just say, if we don't get to I don't think we're going to get to all of the questions today, but if we don't get to your question and you're still looking for some clarification, you can feel free to email us. The email address is there for you to take a look at. This next question is a good one that we get quite a bit. It says, if your organization has a contract with a ministry, do you need to report interactions with the ministry staff in complying with the terms of the contract? So the way that this question is worded suggests to me that the contract is already in place, and it's not about what may have happened in the lead up to the contract, but it's about what happens over the course of the terms of the contract. And I would say that if it's routine communication set out in the contract, then that's not something that needs to be reported. However, in an exceptional case, maybe you're talking about renewing the contract and changing what it would be, or getting the same contract next year, then those kinds of things get into the territory of trying to influence a public office holder. So when there's a set process in place, and we hear this question often as well in the area of grants. So there may be a call for proposals for something because there are going to be grants going out. If you're operating within clearly defined processes that government has set out that already have transparency accorded to them, then that is not considered lobbying. But if you are trying to use those processes to influence public office holders in other areas, then that would be considered lobbying. So what we essentially are always looking for is the question of whether or not you're trying to exert that influence in an area that there isn't already transparency.
I think we've got time for 3 more questions, I'm told, what we've got left in terms of airtime. So it's back to Morag.
All right, so we have another question about the registry. It says, O-Line Twist mentioned that consultant lobbyist registrations will be migrated and auto-filled in the new registry. Is the same for organizations with multiple in-house lobbyists? So I will say yes. It's sort of a yes and no, in that your registration in the current registry will be migrated over. So after you set up your account and you log in, under current activities, it will show you all of your current activities. So if you're a consultant lobbyist with 10 clients and those registrations are all active on April 30th, you have to update all 10 of those. If you're an organization, there'll just be your one registration that you can update. So your basic information will be there, but you will have to sort of basically fill in the blanks of either the new sections for the LTA, such as gifts or contributions. As well, some information that you put in previously may be scrubbed out just because the fields don't translate all that well, but it'll be quite clear. So when you go in, you see sort of a registration summary, and there's, like I mentioned in the presentation, there are 7 steps to completing a new registration. So you'll see those 7 steps, and the ones that are completely filled in already will be green, and the ones that you need to complete more information on will be sort of this yellowy orange color, and that will just let you know that you need to go in there and complete those sections. And my recommendation is that you may want to even go into the green sections and just double check that all that information is the same, that nothing has changed, just to ensure that your registration is completely up to date. So basically the short answer is yes, it's the same for consultant lobbyist organizations. Registrations will be migrated over, but you do need to go in there and update some areas and fill in sort of blank areas for the new sections.
O-Line.
I haven't identified one right now. Hold on just a minute.
Yeah, some of these we're trying to sort of group them in to cover off as much territory as we can. Some of them tend to be a bit more specific. And again, I would encourage those of you with particularly specific questions just to get a hold of us after by email or telephone to address those.
Some of them are also repeating the same question. So for example, if we've been going to meetings with government on a project, this takes place on a bi-weekly basis and are initiated by government, does this fall under the Act? It's the same answer to the question that we talked about before in terms of whether you have a contract set up. if you're working within the parameters of the project and there's already transparency in that process set out by government. But if you are using that relationship within that project to lobby about other things, then those activities would be considered lobbying activities and you would have to declare them in the registry. Another question here is if we are not making financial contributions or gifts and we aren't engaged with senior public office holders, and I think I take that to mean we're not actually lobbying any senior public office holders, do we need to make a monthly report other than making sure the registration is current? And the answer to that is no. You do not. The Act, again, provides for no requirement. If you haven't had any lobbying activities in a month, then you don't need to do a lobbying activity report.
And Morag, to you for the final question.
Final question.
Yeah.
Okay, well, this is a question about the difference between a senior public office holder and a public office holder. And again, this is a common question we get. So basically there's 3 terms in the legislation. And that, you know, in terms of submitting registrations are what is a public office holder, who is a senior public office holder, and who is a former public office holder. So public office holder is the most broad of the 3 definitions. And I won't go through exactly what they are because you can look that up in the legislation as well. We do have an FAQ section on our website that talks about the differences between these 3 terms because they sound quite similar, but they are importantly different. So basically, if you are lobbying a public office holder, that's when you have your 10 days to submit your first registration return. But senior public office holders is that subset of that broader term, public office holders, and those are the people that you need to list in your lobbying activity reports. And then former public office holder is where that's something that you as a lobbyist may be, and you need to declare that in the registry. And you need to be mindful as well is if you've been a former public office holder within the last 2 years, there is that 2-year cooling off period. And then for senior office holders, I'll just mention that those are the ones that you really want to be paying attention to for your lobbying activity reports. So for senior public office holders, we're talking about ministers, including the premier, ministers, political staff, MLAs, political staff. We're talking about parliamentary secretaries, deputy ministers, assistant deputy ministers, and in terms of provincial entities, it's the senior and next most senior ranking of a provincial entity, and the chair or vice chair. Again, we do have quite a helpful area in our FAQs that go into the 3 terms. And if you have any questions about someone that you're lobbying and you're not quite sure where they may fit, or if you're not quite sure if you yourself are a former public office holder, please contact our office, send us an email, and we're happy to answer that question and give you that clarity.
Thanks, Morag, and that's a great segue to thank everybody, all of you out there who have been a part of this presentation. I want to thank you all on behalf of Morag and Deputy Registrar Oline Twist, as well as people behind the scenes who some of you may get to talk to on occasion, Alison Leduc, who is working hard at HQ, and Christy Howes, who's done a lot to help set this up and get this whole thing on the road. We've had almost 400 people engaged through these webinars in the last couple of weeks, which is extraordinary. That in addition to a lot of the outreach work that's gone on, whether we were able to visit you live when we were still able to do that, or otherwise over the telephone. So thank you for this, and thank you for your questions and thoughts. And as we will, I'm sure, be getting more as we get towards May 4th and many after. But as you know, we are always standing by to take those questions and to engage with you. So all of us look forward to your first filings. And with that, I bid you all well and keep safe. And I'm sure we'll be talking and engaging shortly. So thanks to all for being part of this webinar this afternoon.